Now, there are mixed reactions to the Supreme Court's ruling on the vacant seat saga. While some believe the Supreme Court's decision that the Speaker of Parliament, Alban Babing's ruling declaring 4 seats vacant is unconstitutional, others think the Supreme Court should have allowed Parliament to work on its own. Well, the former Supreme Court Judge, Justice William Atuguba, says the Speaker of Parliament, Alban Babing, is bound by the Supreme Court's recent ruling, which overturned his decision to declare the 4 seats vacant. Well, he notes that per the Supreme Court's decision, the 4 affected members of Parliament are entitled to return to Parliament and participate in legislative proceedings. He spoke to my colleague Elton Brobe on the pulse.
And according to this rule, general provisions don't override specific provisions. And so once the specific power about vacancy of seats is given to the High Court, the general powers hanging there cannot override the special provision. Otherwise, that special provision will be rendered completely hopeless.
Meaning the Supreme Court had no business going into this.
Yes, I'm coming. They have a kind of, what do you call it, referential jurisdiction.
Right.
That's to say, this matter, which is a vacancy of parliamentary seat matter, is for the High Court. However, if the parties there contend that some legal provision relating to this matter is ambiguous and it's a constitutional provision, then at 132 requires that the High Court will stay the provisions and refer just that issue of interpretation to the Supreme Court.
In this case, this was not done.
This wasn't, it went straight.
Or this was not exploited.
It wasn't exploited. It wasn't exploited. And number 2, you see, the question of even the referral, when the issue arises, it doesn't mean that any time it's alleged that there's an issue for the interpretation, the High Court automatically must state it will have to consider whether the provision in question is actually ambiguous. If in his opinion it is not ambiguous, can proceed with the case.
But the Speaker, yes.
If a party is satisfied, can go to a Supreme Court on supervisory jurisdiction to quash the view of the High Court and order it to refer that issue to it, or refer the issue to itself for determination. And after determining it, they send that determination to the High Court, and they dispose of the case insofar as the issue requiring interpretation is concerned. But then the final determination of the matter is from the High Court.
Justice, yes. This is a case where an arm of government,
yes,
the leader of an arm of government,
yes,
gave a ruling,
yes,
based on his understanding,
yes,
of what the Constitution says.
Yes.
And then a member challenges that decision.
Yes.
Clearly, one would say that the Supreme Court was the avenue or the platform to bring finality to this matter.
Yes, but their finality, is governed by the same provision. Their finality will come when the court, given that jurisdiction over that specific matter, has difficulty, or the parties have raised a difficult interpretational matter concerning it. They say, oh, okay, this thing is not that clear. So they are bound to refer to the Supreme Court. That's how the Supreme Court comes in. That's how the Supreme Court will come in. But not ab initio. That's just straight away.